Welcome to the North Carolina Divorce Info Podcast, where we get answers to your questions about divorce in North Carolina.
Welcome to the North Carolina Divorce Info Podcast. This is episode 1, How Collaborative Law Creates an Environment of Trust and Transparency. Our guest today is Heidi Stewart, an attorney who practices family, estate planning, and elder law in Asheville, North Carolina. Heidi, welcome to the show.
Thanks, Dustin. I appreciate your calling me.
This is episode 1 of the North Carolina Divorce Info Podcast. And at North Carolina Divorce Info, we cover all kinds of topics related to divorce and family law, not just collaborative law. In this episode, we're going to be getting into collaborative law and how it differs from the standard court model. But I just wanted to ask a little bit about your practice. Now, you don't just practice family law, you also do estate planning and elder law. As it pertains to divorce and family law, do you just handle collaborative divorce, or do you work with other types of cases as well?
No, I actually do litigation as well as mediation. I think it's important as a family lawyer to stay abreast of the current law as well as to engage in relationships with the judges and have an idea of how a court would rule on a matter, which helps me in a collaborative law case to sort of forecast what might happen in a court.
Not a lot of people know about, or not everyone knows about collaborative law. How did you get into practicing collaborative divorce?
You know, I got involved with the International Academy of Collaborative Professionals back in 2000. Earlier than 2000, the North Carolina legislature passed collaborative law statute, which I was very excited about because I come from a background of mediation. I used to work at the Mediation Center, and I know family law can be contentious, and the court is not really the appropriate setting for cases where we're making decisions about people's assets and their debts and their children. Those are cases that really judges don't want to make decisions in. And as a matter of fact, here in North Carolina, we have mandatory mediation for child custody because the court would prefer that parents make decisions about their children, not the court. So it's been quite some time.
It sounds kind of like you're saying that the traditional court process wasn't really created for the particular needs of divorce, of separating a family.
Well, it's with particular to children and that sort of thing. You know, you can do what's called an equitable distribution of marital property, which is an equal distribution or an unequal distribution in North Carolina in the court system. And basically, you are just listing assets and subtracting debts and then dividing that in an equal manner. But, you know, we're talking about people's lives, their cars, their houses, their trailers, their motorcycles, their dogs. And those all carry an emotional charge.
Right. So I know that a number of our listeners probably don't know exactly what collaborative law is or what collaborative divorce is. And so before we get into talking about how it's different from the standard model and how it creates an environment of trust, could you just give a brief explanation of what is collaborative law? What is collaborative divorce? How does it work?
Okay, so basically a couple would each select a collaborative lawyer and they would enter into a fee agreement with them. But then the collaborative lawyer they'd hired and that person, whether the husband or wife, or if it's a same-sex couple, their partner, would sit down at a table together, all four of them, and sign what's called a participation agreement, which is a contract between all four parties that they will use their best effort to work things out in a collaborative manner. And if they are unable to do so or choose to voluntarily withdraw from the collaborative process, then all of the information that has been gathered in the process is not going to be admissible into court. And so that provides security, and the collaborative lawyers will have to withdraw, so they can't go on to court to represent the parties. So there's this participation agreement, which you're agreeing to bring in all of the documents that you need to in order to and not hide anything, and to be respectful of the other person and the other attorney, and basically sit down and work things out in a way that is more collaborative than a court case.
And how's that different from traditional litigated divorce?
Well, in a litigation model, the first thing you do is you hire a lawyer, and the lawyer, usually will encourage the fact that you need to win. It's a win-lose. So basically, you file an action with the court for an offset, like in your favor of the 50-50 split for sole custody of the children. It sets up a whole dynamic of, distrust, and the attorney basically will do whatever they need to do to collect information, which is through discovery or through motions or through subpoenas, which can be very extensive, costly, and time-consuming. And, you usually wind up with one person who has lost, the other person who has won, and neither of them like each other anymore. And this is kind of difficult when you have children that you need to raise together.
Let's talk a minute about that issue of discovery versus the collaborative model. Are some people concerned that in the collaborative model, their spouse it'll be easier for them to hide assets?
Well, basically, in a collaborative law case, you are signing a contract that you will provide all of that information. And as a matter of fact, in the culmination of a collaborative law case is a collaborative contract. It's a contract of separation and property settlement agreement can also include custody of the children. But in that contract, I actually have a clause that if anything has been discovered not to have been disclosed during that period of time, that the portion of that the other party was entitled to shall be divided at the time of discovery. So basically, if you don't disclose it at the time that you're in the collaborative case, whether you forgot to or you tried to hide it and then it was later discovered, basically that clause will take care of that. But, the whole idea of a collaborative law case is that both parties want to come out of the case with something. So, we're talking about not just working things out in a collaborative way, but also, it can be a cost-saving measure. And, hopefully you're going to get out of this situation with some respect for the other party.
It sounds like collaborative divorce often or sometimes costs less than traditional litigation.
Yes, there are cases that are complicated that might cost more than one, but my experience over the years has been that it is not as expensive, even though you each have an attorney. But you each have an attorney when you're going to a court case too.
Now, aren't there other professionals sometimes involved in a collaborative case?
Yes, it's called a collaborative practice group. I've worked with therapists who have talked to the family or talked to the couple about the best way to deal with the children and talk to them about the separation and the whole process. I've had financial professionals like CPAs come in and give their opinion as to different ways that the couple could divide up their assets without having a tax implication or any kind of other detriment to them. There are coaches, divorce coaches, who can coach a person through a process. I had one case where I represented the husband, and the wife, got up in the middle and said, I need to have a break, and she went out and called the coach, talked to the coach for about 15 minutes, and then came back in, and we were able to continue on with the discussion about how to resolve their issues.
These other collaborative professionals, they're neutral? Is that correct?
Yes, the beauty of it is in a court case, each of you have, say for example, someone appraises the house for my client, then there's another appraisal from the other party side, and then we argue over the appraisals in the court, and the judge will make a decision as to what the fair market value of the house might be. But in a collaborative law case, we all agree that we're going to use one appraiser or one financial professional. So in that way, it also is a cost-saving benefit to the couple.
And it seems like if you've got one professional working, and they are a neutral party, that they're going to be focused on finding the best solution for everyone, as opposed to the other situation where they're just going to be trying to refute the other person's analysis or argument.
Right, that's true. Mm-hmm.
This sounds a lot like mediation, which most people are familiar with divorce mediation. How's collaborative law different from divorce mediation, and how people work out their differences there?
Well, it's the same in that it uses dispute resolution professionals committed to helping the parties reach their own solutions. It has more control, more privacy. But, a lot of times in a mediation, you will do something called shuttle mediation. If the parties can't be in the same room together, basically one is in one room and one is in the other, and as a mediator, you're going back and forth between the rooms. In a mediation model, the parties will sit and tell the mediator their side of the issues, and then the mediator assists those two parties to reach a solution. But if one of the parties is unable to advocate for themselves, because of where they are in the marriage, or because they don't know anything about family finances, which I see happening sometimes, or if they don't deal well with conflict, then that party is not going to be represented fully. But in the collaborative law process, the lawyers are there. They're still acting. We've all taken an oath to advocate for our client zealously. So we're advocating, acting as legal advisors and negotiating along with our client. And I have had, moments where I have, asked for a break and gone out and talked to my client to find out what exactly was holding them back from expressing themselves. And then if they told me they would prefer that I express their opinion or whatever their desire is, then I can do that. And that isn't something that can happen in a mediation model. So advice, representation, and advocacy are at the core of the process. And collaborative lawyers can make sure that the playing field is level.
Yeah, I was going to ask how the role of the attorney is different in traditional divorce and mediation and collaborative law. And you kind of answered that there. But regardless of whether it's collaborative or traditional divorce, would I be correct in saying that each party still has their own attorney and they're still advocating for their interest?
That's right. That's correct. Now, collaborative law isn't all for everyone. I mean, there are situations like domestic violence and those types of situations where you're not going to be able to do something in a collaborative way because there is this power imbalance. But most of the time, it is a process where the attorneys can account for the particular client's weakness or lack of knowledge and engage in helping them reach a creative win-win solution.
Do people always have to? I know a lot of people might think, well, my spouse and I can't agree on anything. It sounds like for us to participate in the collaborative process, we have to communicate well or already agree on most issues. Would that be true or not?
No, Destin, I would disagree with that, summation. I actually just finished up a collaborative case where my client basically, didn't feel like she had the financial knowledge that the husband had, and she basically didn't know what their financial situation was, nor did she have any idea of what it was going to cost for her to make ends meet in order for us to negotiate. And because I come from a litigation background and because I have this background, basically we worked out a budget for her with her going back to school, had her check into schools, had her check into places to live, came up with a budget that she felt comfortable with. And, the other attorney and the other party, the husband, brought financial documents, and we sat down and she and I went through them in a separate meeting so that she felt comfortable about what would be a half and half split. And then we talked to a financial professional, all of us together, and made a decision. So I was by her side advocating for her and helping her to understand what exactly the situation was. And in that, she felt comfortable in their final agreement.
You had mentioned earlier, and something you just said reminded me about. You mentioned a participation agreement. Can you tell us more about that?
Yeah, it's actually a contract. It's a document where we all sit down and make formal written commitments at the beginning of the collaborative process between the attorneys and the clients about how the process will be conducted. We talk about the importance of each party providing information and cooperating in the process. We talk about what necessary documents will be needed, any other things that we need to include, and then everyone signs a stipulation as to how this process will be conducted. And this remains in effect as long as we all conduct ourselves in good faith. The core element of this agreement is that the process continues as long as no one threatens or pursues litigation as a means of conducting negotiations. Or if the process breaks down because one of the parties are not acting in good faith, then, we are all agreeing that lawyers have to withdraw and cannot represent either party. And as I said, the information gathered in the process isn't admissible.
It sounds to me like, and you can correct me if I'm wrong, but that participation agreement actually is what helps to create that environment of trust and transparency, because it seems like in traditional divorce, people are often trying to threaten litigation, threaten accusations, and use that to posture their case for the result that they want. And with that, it sounds like the participation agreement sort of takes that off the table. Is that a correct understanding?
Yeah, that's exactly right. I mean, I have referred back to the participation agreement when there are some, concerns about whether the other party is aware that they're not following, what they had agreed to previously. And, as a result of this agreement, suspicion and paranoia decline dramatically because so much more of the project takes place in the presence of both the parties.
So let's say someone's listening to this and they think this sounds like something that might work for them. They like the idea of the collaborative process, but they're not sure if it would work, and they want to find out more about what the next steps are. What would you recommend that they do?
Well, I mean, they could call me, of course, for an appointment. They could go to the International Academy of Collaborative Professionals website, or there's also a Western North Carolina Collaborative Practice website, and the address for that is wnccollaborativelaw.com.
Okay. Well, Heidi, I want to thank you for joining us today and talking about collaborative law.
Well, I appreciate your calling, and I hope you have a great day. Thanks, Justin.
You have been listening to the North Carolina Divorce Info podcast, where we've been talking with Heidi Stewart about the collaborative law process and how collaborative divorce creates an environment of trust and transparency. You can review the show notes at ncdivorceinfo.com if you'd like to learn more about collaborative divorce, or if you'd like to learn more about our guest, Heidi Stewart. Her contact information will be there within the show notes. Thank you very much for listening.
Thanks for listening to the North Carolina Divorce Info podcast at ncdivorceinfo.com.